can. And we may even have another webinar on this topic. I know it's been a really popular topic. So look forward to additional information on that. And today we've got Keith with us, and we really appreciate his time. And like I said, since we're fairly limited on time, I'm just going to go ahead and turn it over and let him start it.
Good afternoon. The Public Commission is to try to upgrade the knowledge both on the part of public officials and citizens concerning their rights to public information and attendance and participation in public meetings. So you have before you an outline that I do not intend to cover in great detail, and some of the functions are laid out in that outline, and those contain cites to particular parts of Chapter 23 of the Iowa Code, which is the chapter that created the Iowa Public Information Board. In the 20 time I was a lobbyist, and I confess to representing the newspapers and broadcasters, among others, during my career. And I'd also been a city attorney, so I had some sense of this issue from both perspectives. And the legislation came about from a study committee that started about 6 years prior to its passage, and it took about 5 years to get the bill passed. And I tell people that I am very grateful for my clients, and it was a very difficult bill to pass rather than believing perhaps their lobbyist was incompetent. But I think some of you probably helped keep it, even when lobbying, that we think Iowa public officials do a great job, and they want to obey the law, and they want to encourage their citizen participation. But that it's awful difficult sometimes to interpret some of these statutes, and I'm learned that there are difficulties in interpreting them. So the idea was to all have 4-year terms, with the exception of some that when we started, they had started on a staggered basis, so some of them got 2-year terms, but now after 2 years they are all on 4-year terms. We have 4 attorneys in the group from various perspectives, and the 9 members are divided into 3 constituencies. Those that have background and members of the general public, or representatives of the general public. The thought being that a lot of what we do in this area, I think, is a result of the fact that it's been difficult to come to agreement on certain controversial issues, and the ability to sit down and have a group that would serve to be knowledgeable about the issues and then also to forge some compromise just didn't exist. So hopefully we will have a group now that can address these issues with authority and with support from the constituencies involved. The board really has attitude. One, of course, is a complaint or an enforcement process, and I'll talk a little bit more about that. We also have an obligation to give legislative input to the governor and the legislature concerning statutory issues that we think ought to, and hopefully we'll have something out to everyone here in a matter of a few days to a couple of weeks. They are going to be dramatic changes, or at least in our opinion, they're not. They're we're off to a small start to try to get things from everyone, and we'll hopefully achieve some consensus, because I think some of you will bring perspectives that we're not aware of, and so we will benefit by your comments when you get a chance to review that package. And I will say before I forget it that we're in this program at the end, I believe, of the hand that you have my name and my email address and my phone number. We'll happily add you to our distribution list. We have a list that we maintain. I think it's got about 150 names on it now, and email addresses where give them wide circulation and invite comments. As appropriate. So the legislative part is still kind of in its infancy, because we really haven't gotten the input yet from affected groups to add into what we've been putting together. Another obligation under the statute is interpretive. We will do rules, three opinions, and declarations. We have one person out there in southwest Iowa who has provided us with several petitions for rulemaking, and so they haven't been fruitful, but he's hammering away. We will do training also, and we work with ISAC and other groups in preparing a training curriculum that I think serves generally all groups, and that's on our website. And the website is also referenced at the end of the PowerPoint that's been put together, and it's kind of a synthesis of the presentations that the League, and ISAC, newspapers, and so on have used over the years to do training, and some of that training I think was done jointly. And we tried to assimilate it into a PowerPoint presentation that would take advantage of the best features of what we're about. And what I want to talk about today, and I think probably the main takeaway that I have for you today, is that I want you to realize that we really have an obligation and responsibility and a desire to be helpful and to make your jobs easier if we can. And we are not to be a gotcha agency. That was my thought from the beginning, and the board and the board chair have adopted that philosophy, as has the staff. And the idea is to be helpful. If you have made a mistake, or somebody claims you've made a mistake, to get onto some kind of a punitive mode. We seek compliance and understanding of the law, and some indication that it will be adhered to. And we have had situations where we've uncovered some errors on agendas or meeting procedures, and the solution so far has been to do some redos of meetings when that's possible. So I think we've done that in school districts, cities, and counties at this point. So we've had great cooperation from officials and the lawyers that attend. So our first starting point generally is to try to work through the attorney representing whatever group it is. In your case, would be the county attorney would be a point of first contact, and when that is available to us, which is not always, they might be gone, or in one case deceased. So and when you don't have that ability to make that contact, it does complicate things. Normally it works very well. If you look on the outline on the second page, you will see the board's powers and duties stated there. And I base subpoena power, and we have these obligations to disseminate information to the public and that sort of thing, and that's under paragraph A of Roman 3. Some interest, I expect, handling of complaints is Roman 4, jurisdictional requirements met. In other words, it has to involve Chapter 21 or Chapter 22, and it has to have occurred, the incident, the basis of the complaint. And I thank God every day for whoever put that into the bill, because we've had complaints from as long as 30 years ago that people come in and try to bring to us and try to get us interested in, and we're very busy as it is, and so we don't need to go back into the ancient history. Legally adequate, if it is, then the board has delegated to me the authority to dismiss one that's frivolous or without merit or outside the time frame, what have you. And it also has delegated to me the ability to act on their behalf to accept a complaint if I think it's got merit and that it has a probability or possibility of leading to a found complaint. Once we get to that stage and we find there is merit, and oftentimes we eliminate the problem before that stage even arises, so a lot of complaints get dismissed or withdrawn fairly early in the process, simply because the public officials involved have responded favorably and take care of the they don't need to take time to go any. It was formed, it was thought that the excuse me, the case load would be about 300, so we're doing a great business, and we wouldn't be able to do that kind of business and not have a backlog, which we hardly have any backlog, mainly because we've had great cooperation from the public officials of this state. The complaint then can go into a contested case if it gets accepted by the board and we are not able to obtain an informal resolution, trying to resolve things between the officials and the complainants. And the statute, as far as I know, is unique in that the first required statutory step is to attempt reconciliation, kind of resolution, try to get a settlement early on rather than subjecting the public and the public officials to the process of economical resolution of a problem and let everybody move on. If that's not successful, then we get into the Chapter 17A contested case process, which I assume most of you have some familiar. Roman 5 talks about the formal opinions and declaratory orders, and the one I want to emphasize is Roman 6, and that is, again, emphasizing that our approach starts from a belief in our public officials, their integrity, and their responsibility. Stem from a lack of knowledge of the legal requirements on the part of the public officials and from the public's ignorance of their rights or understanding of the limitation of their rights under the law. So we try to provide input for the public to act responsibly with respect to their interactions with their government. As I mentioned earlier, we try to do training ourselves. We will speak. We encourage anybody has a group that needs a speaker. Believe strongly that by doing making these presentations and by providing education that the public is better served and citizen participation is enhanced, and the result of that should be we call the hot topics. There have been some more hot topics discovered. Just everywhere I go, I'll find another one. But maybe you'll propose one today. The first station we'll try to find winners. There's no prize. There's no prize money. We don't have enough appropriations to cover all the times that I get stumped. So feel free to email or type in your questions, and we'll try to get to those at the end. But the hot topics, some of it's pretty obvious, but a meeting simply defined in the code as a gathering in person or by electronic means, formal or informal, of a majority of the members of a government body, where there is deliberation or action upon any matter within the scope of that governmental body's policy-making duties. But the code also recognizes that officials it doesn't include a gathering where there is no discussion of policy or no intent to avoid the purposes of merely ministerial or spots to be in under the open meetings law is a three-person county board of supervisors. And I think those of you who are serving in those positions have one or two colleagues. So if it's about a public policy matter, it's a public meeting, and so it's got an impractical results and a lot of times. And I think that a lot of supervisors that I've talked to have the problem that they can't even go to a basketball game or something with a colleague without somebody thinking they're conducting county business when actually they're just enjoying their basketball game. So it's, and I don't know that there is the answer to that. I don't think there is, but that's a situation that exists, and maybe that's one of the reasons. But it is very difficult to comply with the law, and at least not to be perceived in violation of the law. And I think I get complaints from somebody, and they say, well, that they saw them at lunch or something like that, and I said, okay, and so what did they talk about? Well, I don't know, but they were at lunch together doing business. Why do you think that? Well, they had to. Well, I need more than that. Another in August, we had a whole bunch of questions about advisory committees, and I got really involved in that, and was basically forced to when a government body creates an advisory board, I think the best practice is to simply tell them they need to comply with the open meetings law. It's just very, very easy to slide from a non-advisory capacity, as defined in the statute, to one that is covered. And so group, or whatever you want to call it, and give it some responsibility. And if that responsibility results in developing and making recommendations on public policy issues, they are covered by the open meetings law. And if you tell them, well, I just want you to find facts on a certain area, and that's done sometimes, and I've approved that in one instance where they're trying to gather some data and it's supposed to pull that together in a group. without any recommendation. I found that to be acceptable. I got a lot of criticism from some quarters on that, but when you, by definition, say as a qualifier that it's to develop and make recommendations on public policy issues, it's inherent in that definition and that qualification that there are situations when an advisory committee is not covered. But I think the danger is that even a fact-gathering one can easily morph into one that's making policy recommendations is another question, but they often morph into that kind of an activity. I'm asked they use further recording devices at public meetings, but Sue Vandekamp asked me yesterday, late in the day, and that whether or not people could use cameras to get copies of documents, and I did a quick search and couldn't find cameras in chapter 22, and I told Sue that, but she pointed out that the word photography that they contemplated the use of cameras. Well, I agreed with that, and so I think it is covered in statute that people can use photography to make copies of public documents that contained information that wasn't public. And I think that's, you have the same problem there as you do when you're making Xerox copies. And with old documents, some people tell me that flashing or flash photography has some deleterious effect on old books or papers. And I don't know the truth of that, but I think you could probably prohibit the use of flash photography. I also think where we have some problems once in a while is the notice practice. And that is the requirement in the statute. Everybody's aware of that 24-hour requirement. They must give notice within or more than 24 hours before the commencement of the meeting, and that's one issue that's come up, and we're looking at doing something legislatively, and it won't be too radical, but there was a big discussion about that prompted by the Ombudsman's office last fall. And I think it's always been interpreted that the notice had to go up more than 24 hours before the meeting, but it had no requirement that the public have 24-hour continuous access to the place of the notice. So that's become an issue, and I think that after all the years that we've just had the requirement and the interpretation we live with today, that if it's going to change, it ought to be done legislatively. Even the interpretation. But there's one part of that notice requirement that I think is missed, and that is in the first sentence, it talks about the time and the date and place of each meeting, including a reconvened meeting of the government body, and the tentative agenda of the meeting. And then there's that phrase, in a manner reasonably calculated to apprise the public of that information. I have had one case where it was particularly obvious that they posted it in a manner not reasonably calculated to apprise the public of the information, and they eventually agreed and redid that meeting. And what they did was they posted a notice on a Friday morning for an early Saturday morning meeting, and I don't think anybody really was doing that in order to get great public attendance at that meeting. So I think that was recognized, and that situation was promptly remedied. The requirement exists also in that paragraph that the media can request a copy of a notice to be forwarded to them. They sign up with whoever the meeting clerk is, whether it's a city clerk, county clerk, auditor, whoever's doing the agendas and so on, that they wouldn't be county clerk, be auditor, I guess. But anyway, whoever is in charge of that or has that responsibility would get that sent out to the media. Another practice a best practice comment would be to avoid using items like old business or new business. And I mean as items. I don't mind that as categories, but when people just have an agenda that they approve the minutes, old business, new business, adjourn, that doesn't really tell anybody anything. And I've seen notices, agendas that have action on resolution 327. Nobody knows what resolution 327 is. And I think in both of those instances you had somebody who was preparing the agenda that was inexperienced in doing that. The Iowa Supreme Court has said that a notice has to sufficiently apprise the public and give full opportunity for public knowledge and participation. That's the purpose of it, and that's kind of the test that they would look to if it ever were to go that far. And there can be items, obviously, that come up late in the time period. And I know that it's difficult sometimes to avoid having essentially what I would call an emergency item appear on an agenda. If it can be reasonably deferred to a later meeting, it should be done that way. But there are times, and there are provisions in the code that allow for such a last-minute emergency addition to an agenda. But you have several things you have to meet as a test to satisfy that. I think that's in 21.4. I get asked a lot of times about electronic meetings, and I think there's some confusion as to what an electronic meeting is. It's not an internet meeting, but just a plain old telephone conference call kind of meeting is covered in section 21.8. And it's not to be done routinely. It's only or impractical. And then only if the government body complies with several steps. One, you have to provide public access. Two, the place of the meeting is the place from which the communication originates or where public access is provided to the conversation. 3, minutes have to be kept, of course, and those minutes must be or impractical. Now, I haven't heard of anybody that does an electronic meeting getting in trouble on whether or not it was impossible or impractical. I think probably the question is the time, is it impractical? To drive to Sioux City for an Iowa Public Information Board meeting when all we're going to do is pass on routine matters. The last item is that, well, the question is, can I have a closed electronic meeting? And yes, you can. You have to follow the same procedures that apply to any closed session. And I still think I provide public access because the public has that right to closed session in case there's any action that occurs as a result of that closed session. Another issue that comes up, you know, how do I close a meeting, or what are the steps we have to go through to close a meeting, and what are the criteria that permit that? And I think probably everybody on the Board of Supervisors probably are to this, but the members of the body, or all the members present, to hold a closed session, and they have to be within what I call the dirty dozen. There are 12 exceptions to the open meetings law that will allow you to have a closed meeting. You have to take minutes of that closed meeting. You have to record that closed meeting, and the minutes and the recording have to be sealed and kept under seal and available for 1 year at least. And then there are several items listed. You can review records that are confidential records, discuss records that are confidential otherwise. Skipping some of these, but litigation, you can discuss litigation with counsel, or litigation prejudice or disadvantage to the governmental body. Again, the emphasis also is on, in my mind, is the strategy, to discuss strategy with counsel. So you can't just have the board get together among themselves and discuss strategy without attorney present and do it in a closed meeting. Another law enforcement matters, which would enable violators to discuss or to avoid detection if that matter is discussed publicly. And another one is to similarly to avoid disclosure of law disclosed would facilitate disregard of the requirements. Speed traps, I don't know, but it's in there. The one that gets a lot of attention is paragraph I, which is to evaluate the professional competency of an individual whose appointment, hiring, performance, or discharge is being considered. First element. Second element is that individual's reputation. And the third requirement is that individual has requested a closed session. So if you're going to evaluate the competency of an individual whose appointment, hiring, or performance or discharge is being considered, you have to do it in a public meeting unless that person requests that it be held in a closed session and represents that it's necessary to prevent needless and irreparable injury to his or her reputation. There's also paragraph J, which is to discuss the purchase or sale of real estate where premature disclosure would disadvantage the governmental body. And I believe in the last 4 or 5 years, somebody from ISAC got that amended to cover both purchase and sale. I believe it was purchase until...
Yeah, I think a couple of years ago that changed, yep.
And so, and that was done in one of those instances where we all got together and I think passed a bill that had 15 or 20 changes to open meetings and open records laws that everybody agreed made sense to do, and kind of updated the code and addressed some problematic areas, and did it by consensus, and it was a bill that I think everybody in the legislature was happy to vote for. There is a provision in there too that if you're discussing security procedures and vulnerability of passwords and that kind of thing, that under paragraph K you can use subsection 50 of section 22.7 to justify having a closed meeting. L addresses the needs of public hospitals, and that's been amended recently, and I believe that hopefully the version you have before you has the has the citations there in the 4th or 5th line from the end of that paragraph. As I said earlier, the vote of each member to go into a closed session has to be recorded, and the reason has to be stated as to why the meeting was closed. There can be no final action taken on any matter within the closed session. Now, there are some exceptions in the code. The primary one that everybody's aware of, I think, is labor negotiation. If it's a Chapter 20 issue, there are provisions in Chapter 20 that create exemptions from the provisions of the closed meetings prohibitions in 21.5. And I think there are some other ones out there too that I don't have a list in front of me, but there can be exceptions. The sealed minutes and the sealed recording are all confidential, and I say have to be retained for at least a year, and are subject only to be reviewed by a court of law confidentially. The court does that in a confidential manner, and then the court may determine what part, if any, can be released to a party seeking enforcement of the chapter. I read that, but it hasn't been tested. But my interpretation, if somebody were to ask me and I wasn't forced to do any research, would be that I think that means that someone just can't come in and go in and ask a court to review one of these sealed records just for amusement or interest. It has to be done in the context of some kind of enforcement action. Probably the one that I hear most about, and we have a case now that's pending, and that's the one on personnel issues. I went through those elements before, and the other problem I've encountered with that have to do with people who want to do a closed meeting to discuss hiring or firing of an individual, but they want to use paragraph A, which is the discussion of confidential records, or paragraph C that relates to the attorney-client privilege. And to me, it's pretty certain that the statute creates a specific provision relating to evaluating employees or potential employees, and that provision would always apply if it involves evaluation. Now, you could also use, I expect, a combination of A, C, and I, but I don't think you can do any evaluation of an individual without using I. And the portion of the rub there is you cannot have a closed meeting under I unless the subject of that conversation consents to having a closed meeting. They do not have any right to attend that closed session, but I think experience is that a lot of times you'll have, especially with teachers, they will bargain, okay, I will urge a closed session if I'm allowed to participate in that closed session, and I think often that's granted. I think the board or council can make their determination as to who they want into or to participate in such a session. The other question along in this line of closed meetings and open meetings and so on is I get a lot of questions about can an email exchange result in a meeting, or if so, is it an illegal meeting? Of course, if it's not noticed and an agenda published, of course it's an illegal meeting if a meeting occurs, and that again is a gathering of the majority or quorum, and which county business would be discussed. And then people ask me, okay, what if we do this through reply all? And I had a question early on. A lawyer in Waterloo, Cedar Falls, somewhere in that area of the state, wanted to have a city council, as I recall, investigated for having an illegal closed meeting or a series of illegal closed meetings. And so I asked him to supply me with whatever evidence he had of that, and so he sent me a whole stack of emails that he'd obtained from the city, and the emails related to a development. And the developer was communicating on a regular basis with the public works director and with the zoning administrator to develop site plans and a plat. And all of his emails were copied to members of the city council. And I only found one time where a member of the city council made any indication of even receiving the email by asking a question or a clarification on some point that was in one of several emails. and eventually we ruled that did not constitute an illegal meeting, just using reply all, because one, there was no agreement among the council members that they would be available at a certain time to use reply all to in essence engage in kind of a chat room kind of activity. And my other concern was that anybody could come along and send a series of emails and copy the members of a public body. And if I applied the attorney's theory, that would allow an outsider to just drag everybody into an illegal closed meeting. And that's a ridiculous result. So we turned that away. And I did do some more research later on this issue, and the question was raised in the context of a group of council people in a city that were actually engaging in reply all, more or less like a chat room, almost, but not quite. And I found a Supreme Court case that back in 1980 there was a case, Telegraph Herald versus City of Dubuque, in which there was a debate about the what we call walking quorums, and I know many of you know what I mean when I talk about a walking quorum or a serial meeting, where you have a 5-member board and you meet 2 on 2 and 2 on 2 until you get everybody covered, but you never have a quorum, and you get accomplished what you want to accomplish without having a public meeting. And so somebody tried to make a case that when they knew that one council person had spoken independently with 2 other council people to get basically 3 his vote and 2 others on an issue that constituted an illegal meeting, and tried to apply that theory to that circumstance, and the court stated that the theory, quote, ignores the legislature's apparent intent that temporal proximity exist among members of the government body. And I just love that phrase, temporal proximity, because everybody thinks I know what that really means, and I don't. So I think it means close in time, and I think it has more meaning, frankly, in criminal law, but the Supreme Court used that term to say that there's got to be some immediacy or some immediate instant communication involved before it would actually rise to the level of an illegal meeting when you gathered that way and use the reply all. Best practice, don't set yourself up to be the test case. You don't want to be the one that defines what temporal proximity means in this modern age as opposed to what it meant in 1980. And the other thing I say is I have journalists that complain to me about this, and I say, well, really, they're kind of doing you a favor. They're doing a walking quorum, but in the process of doing that, they're making a transcript for you. And so you can go get the record they've made while conducting this public business in this manner. And I don't know if your outline is the same as mine, but I next have a little bit about use of cameras in public meetings, and I'll cover that before I forget it. It's in my outline at this place for some reason or other, and that is that, yes, the public may use cameras or recording devices under Section 21.7, but they don't have a right to just be obnoxious about that use, and the statute does go to say that the body has the ability to make rules, reasonable rules, for the conduct of meetings and preservation of decorum. So it's not an unbridled privilege that the public has these cameras, and I've seen some pretty obnoxious use, and I've seen pretty good use by people that make them unobtrusive and are perfectly appropriate. Segueing into the public records portion of the outline, or the hot topics handout, one of the things we've noticed or experienced so far is that a lot of these problems could be ameliorated if the custodian of the record would communicate with the requester if they're having trouble responding to the request or having trouble finding the time to respond, and get some understanding that it might be a couple of days before I can find that, or I'm not able to find it, and here's the reason why, and we are working on it, we'll try to get back to you. Or you've asked for something, or you've asked for emails, and you haven't really given us good parameters that our IT people can use to find whatever you're interested in, and frankly we don't know what you're interested in. Can you define your search parameters and so on and so forth? And one other thing on that point that I make clear to custodians is that you have been granted the right, and not too long ago, to get upfront payment when somebody makes a records request. And I'll be the first to say that I know in some quarters that the records request has become a cudgel, if you will, to kind of beat on the public official they're angry with, or the public body, or the governing body of a body. And so I know that's going on out there. We're sensitive to that, and we try to discourage that, but we don't have any device. We've been looking at some remedies to that problem, and putting them into a statute or putting them into statutory form has been very, very problematic, and we haven't made much progress, nor have any other states. I get asked, you know, the simple question of what is a public record, and that, of course, is set out by statute in 22.1. It's just about anything of any medium that stores information relating to the public body. That'd probably be the simplest way to sum it up. If it's got information, whether it's written on a chewing gum wrapper or on a thumb drive, it's information that belongs to the public, or that the public has access, unless it falls into the coverage of one of the confidentiality provisions. I also get asked, do records have to be retained for any certain period of time? And I point out that for state bodies, yes, they do. They have an Archive Act that applies. But for local government entities, there are no specific records retention statutes. Now, there are statutes that require record retention. I can think of like bonding projects and financial records and that sort of thing. Those statutes have their own retention provisions within them. And good common sense would govern retention of a lot of the public records. But Chapter 22, the Open Records Law, has no provision relating to records retention. But like I say, don't take that as license to just go out and start burning records, because in fact, ISAC, I think, has probably the best handbook I've seen, and I think it was a draft, listing a lot of statutes that have records retention requirements in them. So I commend you for that. And I think that there will be some legislative interest next session on that issue. Towards the end of this session, I got a call from Senate Democrat caucus staff. One of their members had a local issue relating to destruction of emails by a public entity in their district, and wanted an opinion, a formal opinion on that. And I said, well, I can give you a formal opinion, but by the time I get that done, and the session will be over, if you want to take action, why, I can just tell you informally that there is no such provision under Chapter 22, nor am I aware of any general provision applicable to local government anywhere. And the legislator eventually decided that it was a subject that if they're going to do something, maybe they ought to have an interim study committee, or at least not try to jam something through at the last part of a session. I get a lot of questions, too, on electronic records and private devices, whether it's a cell phone. And so, you know, there's a practice that I see once in a while in a public meeting, and that is members writing notes to each other. Well, those notes are public record. And some people even are using phones to text each other in a public meeting, which I think also creates a public record, both of which could be embarrassing if people think they're doing something clever that way. And I'm waiting for somebody to make an issue of it, but to my knowledge, it's never become an issue. Christy's nodding her head negatively, so far we haven't had any real case on that. But if you're going to use a email or a text message or whatever to communicate about official business, you're generating a public record. And so if push came to shove and somebody wanted a copy of that, they would have you'd have to produce that record even though it might be on your personal cell phone. In fact, I use my personal cell phone. I didn't want to carry two of the darn things around, so I take that risk myself, but I don't really care. They can read all my emails. I don't particularly give a hoot, but they aren't very exciting, at least not to me. But if you are concerned about that, you ought not use it. Get your own, or get a cell phone you dedicate to public use, even if the government body doesn't want to buy you one. But most likely, if you use a cell phone or that kind of device, you're creating a public record. The practical answer to some of this I give is that, okay, I know you're going to use your own computer anyway. I do. And so when you do that, you ought to either use a thumb drive that's dedicated to that purpose, or at least create folders in your computer that you keep your public business in, so that it makes the record search a lot easier when the time comes that somebody wants to search your emails on your home computer. Looks like we have some questions coming in.
Yeah.
Okay, good. The last thing, and the last and the least popular in my mind to discuss, the one that I hate the most, is the issue of preliminary drafts. That was enacted, I believe, the same year as, it was part of the legislation that established the Public Information Board, and like that board, I believe it was delayed. Its effectiveness was delayed until this past July, and it's codified as Section 22.7, paragraph 65 of the Iowa Code, and it's a very prolix and difficult to understand statute, and I believe it's set out in full in your document. And the material you have is really not an official position, but it's something that I put together because I think people ask me about this. They're entitled to some kind of guidance on it. We don't really have an official legal opinion, and I've shown this draft material to various people, including, I think, Christy, you've seen it, and other public body groups have seen it. The governor's office has looked at it, as has the Attorney General. And just about, I know the governor's office and the Attorney General suggest that we, rather than trying to issue a legal opinion at this point, we need to get some factual context to where these issues arise, and then apply them to those, and then get a stream of opinion or theory anyway that is applicable and sound. And I think that's good advice the more that I got into it, because it is a very complicated area, and I think it misleads people in that the way it's drafted, the way I interpret it, it's a very narrow exemption, and it's probably applicable in a very few situations. I think it's especially troublesome at the local government level, in that the way it's drafted, it envisions layers of government, where you have somebody doing drafting on an idea that perhaps the person who makes the ultimate decision doesn't even know you're working on, or it's some unsolicited input, and hasn't gone through any kind of review or process. And the That's one situation. The other one is that there's a call for, well, say a state of the state address. And the staff, eager as they are, they all want to make a good impression on the governor, and they come up with all these ideas. Well, the governor looks at those. Jamie walked in. Jamie's been there. He's been in those meetings.
I have.
And so they get into those meetings, and somebody will come up with the most off-the-wall kind of idea you can imagine, and the governor doesn't want to have it said that he even considered such a thing. So I think that's the genesis of the idea, and there are several tests that I came up with in order for the exemption to apply, and they're numbered 1 through 4 on the outline of the handout. I tell you the page, but I think my page, oh, it's on page 13. Okay, it's on your draft. So they have to be tentative, preliminary, draft, speculative, or research material. I don't care what you call them. The name is not important, so don't go out and buy a draft stamp or even a preliminary draft stamp. That's not what's going to count. But it does have to be a tentative, preliminary, draft, speculative, or research material kind of document. And it has to exist in a form prior to completion for the intended purpose. Wonderful. They have to exist in a form prior to the form of the record that is submitted or used in the actual formulation, recommendation, adoption, or execution by any official policy or action by a public official with authority to make those decisions. So in other words, if you're working in a small office and the person you're drafting for sits at the next desk, is not going to meet those 3 tests. And especially number 4, it must not have been submitted to or used by a public official authorized to adopt or execute official policy. So anytime it's used by them, well, then it's a public record. So yeah, I think it's a very convoluted solution to a problem, and I admit to some responsibility for it, but we actually had 2 people tasked to try to come up with a solution to this, one on the government side and one not, and they thought they had agreement, and now both of them don't really agree with what the interpretation ought to be, and I don't agree with either one of them. So it's convoluted, and I just would say, since you got to determine who a decision maker is, and you got to determine who makes public policy, and you got to determine what the genesis of this thing is, and when do you determine whether it was a preliminary draft? You know, one part of me says, well, you can't even make the determination until you have a final draft. Well, what if you never have a final draft? Is there a preliminary draft to a preliminary draft? I don't know. So you can drive yourself crazy trying to figure out all the permutations that can come from this bit of language. Another one that comes up a lot is the old 22.7.18, the confidential applications for employment. And I always kid the regents. It comes up a lot of times, especially when they're hiring coaches. And I've expressed to them, I thought that if they had better reputations, that people wouldn't be hesitant to apply for jobs with them, but that doesn't seem to solve any problems. But you can take a look at that, and it's got certain criteria within it, within that paragraph 18 that have to be satisfied, and it's good to kind of look through that once in a while. It's communication not required by law, communication not required by law, made to a government body or an employee of a government body by people outside the government, and to the extent the government body could reasonably believe that those people would be discouraged from making that communication if they were to know it was public. And then there's provision releasing some of the information if you can do it without indicating the identity of the submitter. And it has the kind of based on the law enforcement privilege, and that is the information is contained in it that relates to date, time, location, immediate facts and circumstances. That same language appears too, but if that can be released without identifying the submitter. And the last one, before we get into the questions, I'm anxious to see what the winner is this time around for being able to stump me, or how many there are. But personnel files, that's always a problem with us. And finally, secret settlements. Chapter 22 has section 13. 2213 dictates that when a government body reaches a binding written settlement agreement resolving a legal dispute where the damages are claimed or some kind of equitable relief, which could be injunctive relief or a mandamus or mandate that they do something. If a settlement is achieved, the government body shall, upon request and to the extent otherwise allowed by law, prepare a brief summary of the resolution of that dispute. And it shall identify the parties, the nature of that dispute, the terms of the settlement, whether any payments were made, and by whom, to whom, and any actions taken as a result by the government body. And it goes on to say a government body is not required to prepare a settlement if the settlement agreement itself contains that information. And it also says, the last sentence I think people don't realize, the settlement agreement and any required summary shall be a public record. So by preparation of a summary, you have not relieved yourselves of the obligation to release the settlement agreement itself. Let's go to questions.
All right. I will just kind of take these in the order that we have got them. The first one is a question talking about going to a closed session to discuss employee performance. There's apparently a case out there I'm not familiar with, the City of Oldline v. McDonough, and I don't know if you've heard of it either.
I'm not familiar with it.
Okay.
So I've read it, I've forgotten it.
I was going to say, it sounds like it's fairly recent, so we may not be able to answer this question. They were just wanting an opinion on it. Apparently the district court ruled that there's a violation of the open meetings to discuss performance of an employee because it did not cause irreparable damage to the employee's reputation. Which I suppose that would be one of the criteria, so I don't know quite how they got there, but...
I don't know either. I think that's always been part of the criteria. I don't know that it's been interpreted, and that's an interesting one. We'll have to make a note of that one and see if we can find that later.
The next one, can the board discuss union negotiations with a personnel director and request that everyone leave the room? And do they need a closed session with a motion in the minutes to do that?
That's governed by Chapter 20 of the Iowa Code, and I even forgot to bring my rules with me, but you have to look at Chapter 20 for guidance on that, and as I recall, Chapter 20, that there are specific items listed in Chapter 20 that are outside the purview of Chapter 21. So they supersede the open meetings law.
Then there was one on section 21.9, says employment conditions, discussion of employment conditions, it says is exempt from the chapter. So the board discusses non-union employee wages or benefits. Does it have to do anything in terms of agenda minutes, public access, etc.?
Yeah, 21.9 is intended to give the same flexibility with negotiating agreements with non-union employees as the union employee would have under Chapter 20.
Okay.
So it's intended to give that same opportunity to a government body to do negotiations with non-union employees under the terms of Chapter 20 as it relates to the open meetings law.
The next one, I think this came up, I was at the county attorney's school. Was it last week that you guys were there?
Mm-hmm.
Question coming out of the Des Moines Register article from Muscatine County. where there was some critique of Muscatine County's email retention practice. And so this person was curious about if you had any direct advice for counties about email retention that is cost-effective and practical.
Short answer, no. I think everybody's got concerns about email and how to manage it, and I know it's very difficult for me because I get, I don't know how many a day, and you're supposed to, as a state entity, preserve those, and the state's got it set up so they are preserved for a certain period of time. I don't know what options are available at the local government level in terms of what your IT people can provide for you, but it is a difficult question. I do not think you have the problem that a state employee has in that you don't have any obligation to archive emails that are non-essential or don't fall within certain criteria, whereas state employees do. So I think if you have an email that served its purpose, I'm not aware of any reason, if it's not covered by some other policy, if it's not relating to a bond issue or one of those other things I mentioned earlier, I think you can delete it. And frankly, if I get an email that's a chain email, I might delete some of the bottom of the chain just to get the clutter out of my email box because the message is retained in another email. Or if it's an email that if you and I, Christy, are just setting up a meeting, I don't see the necessity of saving all those. But I don't really have a crusade out to get rid of them either. But I don't really worry about getting rid of ones that have no usefulness. And I know at the state level they are working on trying to define non-essential emails or non-essential communications. And I know Pam Griebel's working on that, and she's talking to me a little bit about that, and I'm glad it's her job and not mine.
Yeah, that would be quite an undertaking.
It is quite an undertaking.
The next one is about the ISAC. This might actually be a question for us. It's a question about when will the record retention draft manual be completed. We have sent out reminders to all the affiliates that were initially contacted that while it's an ISAC document, we're really kind of just coordinating it. All that information came from the affiliates. So we had some affiliates that we hadn't got information from them, or maybe they were still working on some of those things. So we have contacted them. We're trying to get it finalized. But important thing to remember about the use of that document, even if we finalize it, a lot of that, it's not law. I mean, there's law references in there, and like Keith mentioned, there are places in the law that talk about requirements, hard set requirements for record retention. But a lot of what's in there is just best practices that have been compiled by the various affiliates. So it's important, even if it's not a draft, to understand that when you're using it. It's not the do-all, end-all, but a very good starting point if you're looking at coming up with your own policies on record retention. But along with that question, Keith, probably this part would be for you. The person was curious if you had any opinion on keeping copies of newspaper public notices and blueprints or land use maps that are already in place or have never come into fruition.
I didn't get the last. I didn't understand the last part.
The last part is blueprints or land use maps that are either already in place or never happened.
I think those are. You're well advised to save those. You have requirements that depend on giving public notice and publishing public notice. And I'm segueing again back into how you cover bond proceedings and those kinds of financial proceedings, budget amendments, that kind of stuff that I think ought to be kept. You do have or could have, if the newspaper goes out of business, it's not any good, but there is, of course, another repository of people that have that newspaper, including the newspaper itself, but I think you're advised to keep those.
The next one is about text messages, and you're talking about, if somebody's texting during a meeting, that's probably creating a public record. How would you provide a text message to a requester? Can you forward it? Or if you've erased it, do you need to go back and try to get it from the person you sent it to if they still had it?
I'm not sure on that. To me, it's a technological issue, and I've been told we actually have a case right now where somebody's trying to get that information, and I haven't gotten the answer. It's actually the employee has used a cell phone and for this, and they're cooperative with the public employer, and the citizens seem pretty patient about it too. And in fact, I don't know, but maybe the thing's just fading away. But there is apparently a way to retrieve those text messages, but I have no idea how you would do it. I don't know how I would do it on my phone. I don't, to my knowledge, once you delete them, they're gone. But I have a chain of them on my phone because I don't go through and delete them. But I don't know that they're backed up in the cloud or what goes on with them. But if they're available, somebody can probably come up with them.
The next one is about question about rationale for why government groups are prohibited from deliberating and discussing hiring decisions in closed session.
Well, the whole issue of employment has always been a controversial one. So you have Chapter 20, which is the public bargaining unit, and that was highly controversial. And you have this issue, and then you have employment records. All of that's been very controversial, and the unions have always taken a position of trying to give as much control to that as possible to employees, and they object to, most recently, to changes in the personnel records statute. And they have good reasons. I mean, they say that it's unfair to give a complaint out that was made against an employee who was later found to be innocent of whatever that charge was. And so I respect what they argue in defense of what the law is today. And from the standpoint of wanting to go into a closed session to discuss employee evaluations of decisions, that, again, as I recall that issue developing over the years, it was urged by, I believe, the teachers union, that they wanted the ability to control whether that was going to be a closed meeting or an open meeting. And I think their concern was that they were involved in some kind of a controversy, that they would have the opportunity for the public to hear the discussion of why they weren't going to be retained, and they could have supporters attend the meeting, that sort of thing. And I believe that's kind of the genesis of the provision that allows the employee to control whether or not it's open or closed.
Okay. We've got another question. A settlement with an employee who is terminated, is that a public record?
I believe once I don't have that statute right in front of me, but as I recall, the statute says that once they're terminated, if discipline is a termination and they've exhausted all their appeal rights and so on, then I think the fact of discharge is public. And I don't know that the reason for discharge is public, but the fact that they were disciplined to the point of discharge is public information. Is that square with it? You remember,
yes,
Christy?
Yeah. Correct. Okay, we've got one more here. Okay, they said there's an AG opinion for the Iowa Department of Public Health about not authorizing to personally copy vital records from a county recorder's office with a digital camera or video recorder. As a recorder, the Department of Public Health tells us not to allow cameras, so what should we do? That might be the one that's stumped.
Yeah, I think that's Sue's question, and that I'm not sure I understood the last sentence there. As a recorder,
so I think as a county recorder, they're probably getting advice from the Department of Public Health that says not to allow cameras for those records.
Yeah, I think, and I was going to follow up a little bit with Sue on that. I think the Department of Public Health records are talking about our vital statistics records, and I think they're treated differently than other records, but by code. Now, I don't know what the issue is on using a camera. I mean, I don't know whether I don't know what the reasoning is for that, and maybe somebody, well, if we were in a chat room, somebody could pipe up and tell us maybe, but I think that it would depend on what limited number of records that would include, and that would, to me, be just the vital statistics records. And I've kind of forgotten now how many of those are retained at the local level these days, but I don't know of any reason other than that would preclude the use of cameras in a local county recorder's office, except, well, it wouldn't be any different to me than using a Xerox machine. Sue mentioned the impact that she was concerned about using flash on old record books, and I don't understand what the concern is there. They're not, and that's not to say I don't agree with her. I just don't know. I mean, I don't know enough to agree with her because I don't know anything about that problem. But if there is such a problem, I think one of your duties as a recorder is to preserve the public's records. So if that use of a camera would impact that, I think you could certainly preclude the use of a flash attachment or a flash device. But to just use a camera itself, I don't know why that could be banned, because I think, as Sue pointed out to me this morning, there is a provision that mentions photographic copies and so on. So to me, that contemplates the use of cameras, as Sue pointed out. I'd forgotten that was in there, but so.
Yeah, so for the recorders that we've got out there, it sounds like Keith and Sue will kind of work on that issue. You know, if you've got an AG opinion on the topic, maybe send it to one of us too, and that might help us sort out what that rationale is for those recorders and cameras.
Well, and Sue, you can educate me further in what you know about this, but that's kind of my take on it with the limited research I did earlier this morning.
We got one more in. Is an electronic posting of an agenda adequate?
No. 21.4 has specific provisions relating to where you have to post a notice. And I know that's in the outline somewhere, but I usually carry my little code book around, but I got a couple phone calls. I was getting ready to leave, and I left the office without bringing that along. And that's 21.4, I believe, says that you have to post the notice at a place where the meeting is going to be held. I think it's certainly a good practice to publish notices electronically, and I also encourage people, and I think it may make record requests easier, and that is to, we disseminate all of our information that we can on the email, and we have that list, and I encourage you to get in touch with us if you want to be on that list. And you will get all of our information. Our board packets go out on that. They went out today with our board agendas. Our board meeting is on Thursday, so the public has the same information the board got Friday. They get it on Friday, so that if they want to take something off the agenda or add something, they can do that by noon on Mondays. But yesterday afternoon, that went out to everyone, and I encourage that because people can find information that way if they want to take the time to look. We also post a lot of information on our website. I'm aware of some municipalities that post everything they can think of on the website, so they can send people there and they can have a field day looking for whatever it is they want to look for. And I got an email just before I left from a county that has a whole bunch of things on their website, so the records I needed to find I could get right to them because they've already posted them. So just posting a notice on a website won't do it, but I certainly encourage doing that because frankly I think it's better for people that have computers than posting it where you have the meeting. But
yeah, I think right now the language, as I pulled it up, it says posting the notice on a bulletin board or other prominent place which is easily accessible to the public and clearly designated for that purpose at the principal office of the body holding the meeting, or if no such office exists at the building in which the meeting is to be held.
yeah.
So it kind of contemplates a physical
Yeah.
locations. We had another question come in. An advisory group meeting that is declared an open meeting, 24-hour notice has been made, agenda provided, minutes recorded. Do those minutes have to be published?
No, I'm not. We don't have any jurisdiction over publication requirements, but I'm not aware of any need to publish an advisory committee.
There's a different chapter that talks about publication for Board of Supervisors minutes, and then 2080 entities have a publication requirement for their minutes, but probably just for an advisory group, you wouldn't have that.
Yeah, I'm not aware of any requirement.
Anything else?
Well, let me conclude by thanking you for the opportunity to present, and want to encourage you to contact me, or my deputy is Margaret Johnson, who used to be a county attorney in Fremont County, and either one of us would be happy to be of help. And if you have a question, don't hesitate to ask, or if you think maybe there's a mistake that's been made, don't hesitate to ask us to help you fix it. And we are not out to entrap anybody or prosecute anybody, and if I can do my whole tenure with never having to fine anybody, that would be just fine with me. So we want to be, we're from the government, and we want to help.
Well, thank you, Keith, so much for your time. We really appreciate it. And thanks to everybody that attended. If you've got other questions that come up, like I said, definitely feel free to contact Keith's office. If you've got any comments on how the webinar worked, we'll get a evaluation sent out that you can get those comments to us, and look for more webinars to come from ISAC in the future. So if you've got ideas for future topics, let us know those as well.
Yeah, we'll be working with ISAC on our legislative package, so you can either input directly to us or through Christy, or however you want to do it. But we'll be working together as much as possible on all of the issues that we address.
Absolutely. All right.
Thank you.
Thank you, everyone. Oh, and the handout will be online, and the recording as well. So if you want to go back and re-listen to anything. All right. Thank you, everybody.